Good afternoon, everyone. Today is Thursday, May 2nd, and our tax category for today is license and inspections. We are convening a session of the Philadelphia Tax Review Board. My name is Melissa Andre. I'm the executive director. And with me today is our chair, Paula Weiss, as well as board members John O'Connor, George Matthews, and Nancy Cameradiner. Twice.
I am here.
So please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy. And by continuing to be in this meeting, you are consenting to being recorded. Lastly, this recording will be posted on the Tax Review Board's website. At this time, I'm going to hand over control to our chair, and I'm going to walk over cases 2 and 4.
Oh, is somebody here for number 1?
I'm not sure. I thought it would be an attorney from either the city, but
All
not for the. I don't have anybody for the petition.
Okay, we'll keep going and see what happens. Good afternoon, everyone. Tax Review Board hearings for May 2nd, 2024 are now in session. As Melissa Andre has explained, I'm Paula Weiss, chair of the board. We're going to go through our list and start with some housekeeping, and that is case number 3, Airfill HVAC LLC, 109 North 63rd Street. Last 4 digits of the docket 9744 has been continued. Moving up to case number 1, Gilbert Powell, last 4 digits of the docket 9240, property 5312 Wayne Avenue. We have that listed today as a status hearing for the board to hear from the parties as to, I think this was on a litigation hold, where that stands and what actions are necessary for the Tax Review Board to move forward, or some timing for that. So that does not appear someone is here for Mr. Powell, but who has this matter for the city?
Good afternoon, members of the board. Mary Costello on behalf of the city of Philadelphia. So I am here to report that litigation ended. The matter has been settled, and as part of that settlement agreement, the invoice in question, excuse me, that was appealed was resolved. So
Okay.
that matter is now moot.
Could you, or did you, as part of that, include that this petition should be withdrawn?
I honestly am not sure, because this was handled by the torts unit, which is different from my unit, as part of a lawsuit that was filed by Mr. Powell against the city of Philadelphia. But I do know that there's no longer a bill for him to appeal, essentially.
You can mark this as no action.
No action needed,
based on the fact that there's nothing due and owing.
and he can get back to us if for some reason that doesn't meet with his
Yeah, we'll
understanding.
send him a letter saying that is no action needed, and of course he'll be able to, request a rehearing if something is not right.
Okay, so I'm going to ask for confirmation from the rest of my board members for a no action needed determination on case number 1.
John O'Connor, I concur.
Nancy Cameradiner, I concur.
George Matthews, I concur.
Paula Weiss, I concur, and that ends case number 1. We're going to move on to cases 2 and 4. We'll wait for Reginald H. Johnson is the petitioner. We're going to wait for Mr. Johnson to come into the hearing room. Okay, good afternoon. Mr. Johnson?
Yeah,
Yes, my name is Paula Weiss, Chair of the Tax Review Board. And who do you have with you today?
this is my fiance, Michelle Selecki.
Okay, are you both prepared to testify in these matters today?
If necessary, yes.
Okay, so Mr. Johnson, would you state your full name for the record, please?
Yeah, it's Reginald Johnson.
Do you swear or affirm the testimony you're about to give in these matters will be the truth?
Yes, I do.
Thank you. And ma'am, could you state your full name for the board?
Selecki,
Could you spell your last name?
Siedlecki.
And do you swear or affirm the testimony you're about to give before the board in these matters will be the truth?
I do.
Thank you. So there are 2 cases on our docket today, Mr. Johnson. Case number 2, I think they're both the same property, 534 East Penn Street. Case number 2, last 4 digits of the docket 8669. Case number 4, last 4 digits of the docket 8668. We're going to turn to the city right now to get the periods and time and numbers that are in question that you're challenging, and any opening comments from the city representatives, and then we're going to come back to you for you to explain to us why you're here, what you're looking for from this board. So who has these matters for the city?
And just before we get started, one of the matters has settled.
Ah, which one?
So it's the docket ending in 8668.
Case number 4.
Yes, and he did just come to my office and sign that settlement agreement, so it is fully executed.
Oh, okay. Does that meet with your understanding, Mr. Johnson?
Yes, it is.
Okay, so we have case number 2.
So wait, what are we doing with case number 4? Is that no action needed or?
Mr. Johnson, are you withdrawing that petition?
Case number 4, I'm not clear.
The case number that you had that Ms. Costello has said you just settled, which on our docket is listed as case number 4, but you've reached a settlement on that bill. So can you state for us that you're going to withdraw your tax review board petition?
Yeah, sure. I don't have a problem with that. It's just that you were confusing me. I thought that was 2 and then you said it was 4, so.
I understand. The matter specifically that you have agreed with Ms. Costello to settle.
Yes,
So that
I
matters.
withdraw that petition, yes.
Okay, thank you. And then we're going to move on to the outstanding petition. Ms. Costello, is that yours as well?
Yes, it is.
And do you have anyone here who's going to testify in this
I-
matter?
I do. I have Lashika Mitchell here on behalf of the department.
Thank you, Ms. Mitchell. Good afternoon.
Good afternoon.
Would you state your full name and position for the record, please?
Sure. Lashika Mitchell, Code Inspector for License and Inspection.
Ms. Mitchell, do you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes, ma'am.
Thank you. I assume that you have the dollar amounts and period of time in controversy?
Yes, ma'am. Okay, so for address 534 East Penn Street, docket number ending in 8669, bill date 9/8/2016, bill number 5540233, principal amount $1,153.70, admin charge $242.28, interest $508.81, for a total of $1,904.79.
Thank you. Ms. Costello, any opening comments?
I just have a few. So this petition is a little bit different. There's been a lien that's been entered on this property, and do I have permission to share my screen?
Yes.
Okay. So you can see here, with what's been marked as a City Exhibit A, the lien information, and I can zoom in too so that you can see it a little bit better.
Thank you.
So there's 2 outstanding liens on the property. One of the liens we just spoke about that was been settled. The second lien is from August of 2016, and that lien is still in effect. And because that is now a lien and it's no longer a bill, this falls outside of the purview of the tax review board, and it would fall under the municipal claims and tax liens law. And that law would require the petitioner to file with the Court of Common Pleas, and then the trial court decides how that lien would be handled, disposed of, and the amount. So that's the first issue.
Can I ask a question before you move on from that?
Sure.
So the August 16, 2016 date that you've given us is the work date. When
Right.
was it liened?
So the lien, typically a lien would be entered within 60 days of non-payment of the bill.
But
So
you don't
this
have a date.
this bill originally went out. The clean and sale was performed on August 26th of 2016, and this bill went out on September 8th of 2016. And then also based on the lien number, you can see that it went out in October of 2016.
How can I see that?
10/16.
The digits in the lien number.
Oh, the lien number. Okay.
Yeah.
That's But that's the number. Okay, thank you. And you had another point you wanted to make?
So that's the first issue with this case, and then secondary to that issue, the fact that it wasn't brought in the proper venue. Just like to turn your attention to what's been marked as city exhibit B. This is also public record. This is the deed for the property. This petitioner did not purchase this property until May 9th of 2018. So the bills themselves, the work that was done, all of that happened in 2016, when the property was owned by Veresta Bland. So so the issue with that would then be standing. He never received that bill. That bill was never issued to him. He was never responsible for that bill. That bill was issued to the property. It was issued to the prior owner, and then it became a lien on that property. And that lien was present when he purchased the property. So typically when you would purchase a property, you would get a title search done. But for whatever reason, that wasn't done here. So that lien was not discharged when he purchased this property.
Any other comments?
And we would just say for those two reasons, this is not within the jurisdiction of TRB. It wasn't brought to the proper venue, and then also the petitioner has no standing. Even if it did fall within the jurisdiction of TRB and it was not a lien, the petitioner would have no standing to file this.
Okay, thank you. Mr. Johnson, we're going to turn to you. You can stop sharing your screen. Can you explain to us when you first became aware of this bill, what your position is, what you're looking for from the board?
When I first became aware of the bill, it was a bill for a commercial trash pickup, commercial trash collection. And I contacted L&I and I said, I don't have no commercial trash collection. And they went back and forth for a minute. And after that, they sent me a letter stating that the information that they sent me was incorrect and they would inform me later of, correct information. So maybe 9 months later, they sent me another notice stating that it was a commercial trash collection bill. So at that point, I came down here to the review board to file a complaint or appeal because the property, even before I had the property, wasn't associated with commercial trash. When I got down here, at that point, the review board said, you don't have a bill for commercial trash or a lien for commercial trash pickup. She said, the only thing that we see here is a clean and seal bill. So I made the appeal out on that clean and seal bill because that's what they saw. So initially, before I appealed this, that's why my argument was there, because I felt as though, it was incorrect information. It wasn't mine. I had no understanding of it. But at this point, they've clarified that that was supposed to be when they boarded the house up in 2016. The reason that I didn't have any prior knowledge of that lien is because the house was slated for demolition. It was going to be taken down, and I actually went into court and got an emergency order. So everything that I'd done to obtain that property before it was demolition was done quickly so that I could, get it before it was taken down. And I did that, and, putting things together, following the permits and making safe as I was supposed to, it's back up. And now I'm seeing this bill. My argument more so is not that that bill exists. I don't know. But my argument is that I had experienced, like, I would say 6 incorrect bills that came to 534 East Penn Street. And those 6 bills that I received belong to 536 East Penn Street. It came to my address with my name on it. And L&I later corrected them. Each time they came, they corrected them. So it just makes it difficult for me to go back the property that I didn't own and, you know, knowing the errors that they made to just give somebody $1,800, you know, or, you know, for that bill, because to me, it feels like, had that bill been paid? You know, did that bill exist at one point? So that's was my main purpose in being down here, was to dispute that bill, and because of the errors, there's several errors that they were making and that they still make to this current day, you know, in the past, recent past.
I understand your position. I have one question for you, Mr. Johnson. When you purchased this property in 2018, did you have a title search?
No, I didn't. And I explained that that was because of the house about to be knocked down. So I just moved hastily to obtain the property so that I can get done what I needed to get done and the demolition wouldn't happen. And that was through an emergency restraint order that I had stopped the demolition. So I was moving hastily, and no, I didn't, you know, cover all those corners.
And I didn't see it on the deed. What was the purchase price?
It wasn't a purchase price. It was a transfer. It's like a dollar transfer.
Okay.
The
Costello?
property originally belonged to my mother.
Okay. Thank you. Ms. Costello, did you have any questions for Mr. Johnson?
I do not have any further questions.
Okay. Mr. Johnson, was there anything else you wanted to tell the board
Well,
that you haven't already mentioned?
yeah, it's just that, like I say, you know, I put a lot of time, put a lot of money into the property. I understand how liens work. I said my part. You know, you know, if it's any way that this can be, you know, a solution where, you know, some kind of breakdown or something, you know, I'd be willing to, you know, I don't have a problem with that.
Okay, the board's gonna step aside. Oh, I'm sorry. Does anybody else on the board have any questions?
No.
No. I think we're gonna step aside for a few minutes and go over all the material that we have in front of us and deliberate and hopefully come up with a decision.
If everyone just stays exactly where they are. Thank you. Nancy, you have to go in through your phone as well.
I'm on, oh, okay.
John, you're sideways again. Thank you. All right, I think we have everybody.
Yeah, George is here. Okay.
All right, the Tax Review Board is back on the record. Thank you all for your patience. Mr. Johnson, the material, listen to your testimony, the material provided by the city, and it is a decision of the Tax Review Board that we are going to deny this petition due to a lack of jurisdiction. This matter was the subject of a lien well before this was appealed to the board, and that therefore it is beyond the jurisdiction of our board at this time. You will get a letter from the Tax Review Board with that decision in about 2 weeks. Both parties do have the right to appeal to the Court of Common Pleas should they so desire. That information will be in that letter. And I need concurrence from fellow board members that this matter is denied. John?
I concur. John O'Connor.
Nancy?
Nancy Camerino, I concur.
George?
George Matthews, I concur.
Paula Wentz, I concur. So, Mr. Johnson, thank you for coming in today, and you will get a letter with our decision in about 2 weeks.
Can I ask you, the jurisdiction of this matter, can I appeal to that? Would that information be inside of the letter that you sent it?
You can appeal our decision, yes, to the Court of Common Pleas. That will be in the letter, and then there are other procedures under the Municipal Claims Act for dealing with liens.
All right, so one other question. So going back to the hearing that I had prior to this, where they reduced the taxes, I mean, the interest and penalties, and just left the principal amount. So has that been wiped off, or do I still refer to that?
Yeah. Once you come to this board, everything resets and starts again. So any prior decision is no longer valid.
Okay.
Okay, so thank you for coming in. We're going to move on our docket. It's cases 5 and 6, and I believe the taxpayer is.
She's here. She's not in the picture though. Hopefully she will come soon. I told her.
Ms. Surain?
Sumrine? Yeah, there she is.
Okay, thank you for your patience. I think we're ready to move on to cases 5 and 6. 1745 North 26th Street. Last 4 digits of the docket for case number 5 is 9086. Case number 6 is 8693. I think we're going to start with case number 6 because I understand the city has requested a continuance in this matter.
That's correct. This is, for the record, Jeffrey Cohen for the city of Philadelphia. I had requested a continuance of case ending 8693 because until very recently, I thought that that was actually a companion bill to the demolition and not a separate clean and seal. That confusion and misunderstanding was worked out, but in the interest of getting this done properly, the city requested a continuance of just that matter so that we can deal with the clean and seal bill.
Yes, and I believe that the board did approve that continuance request. So, Mr. Ray, I have a question for you, and that is, we can go in 2 directions here. We can hear the demolition portion, the demolition bill. I believe, Mr. Cohen, you're prepared to go forward on that?
Yes.
Yes. Or if you feel that, if you believe these 2 cases are interrelated and want to hear them, have them heard by this board together, we can continue both cases. But I believe that that's really your decision right now. Ms. Surain?
Yes.
Yes. Did you want to go forward on only the demolition case at this point? Did you want to hold off on that since we're not going to do the clean and seal today?
The one ending in 9893, we're not doing today?
8693. We're not gonna, that matter has been continued. City needed extra time on that one. The demolition case, which ends in 9086, we can move forward today.
I don't have the numbers. I don't, my numbers don't, 9086.
Right. You filed 2 petitions. One is a demolition bill and one is a clean and seal bill.
She actually filed 4 petitions, and I think that's
Right.
not
That's fine. Okay, I'm not.
So
bored
I
with
just
that.
want to clarify.
Go ahead.
Do you have the bill numbers, Ms. Sumrine?
I do. The account numbers I have.
Perfect. We are case number 5, which ends in docket number 9086, is associated with the bill 022008481, which is the
Okay.
demolition, right?
Okay,
Now for case number 6, which ends in docket number 8693, and the bill ends in 6161. We cannot proceed with that because the city's witness is unavailable.
how much is that one for? What's the lien on that? What's the lien amount?
I believe the clean and seal is around $48.
Yes.
Yeah, that's not a problem. I can make the payment for that one.
Okay, so are you withdrawing that petition then?
Yeah, the $48 one, yeah.
Okay, so that's, Mr. Cohen, the number 6 is going to be withdrawn, and we're going to move ahead
Thank
then
you.
with, there you go, with the demolition. And what bill number is that again, Ms. Andre?
That is 022008481.
Right.
All right. So Mr. Ray, would you please state your full name for the record?
Yes, Rehab Summary.
And do you swear or affirm the testimony that you're going to give in this matter will be the truth?
Yes, I do.
Thank you. We're going to move back to the city's representative to get the periods in question and the dollar amounts in controversy. And then we'll come back to you for you to explain to us why you're here and what you're looking for from this board. Mr. Cohen?
Thank you. Actually, well, let's let Ms. Mitchell from LSU read the numbers into the record, but then the city has, I'll keep it brief, but brief opening
Opening
argument.
remarks. Yes,
Yes.
Ms. Mitchell?
Okay, 1745 North 26th Street, docket number ending in 9086. Bill date 11/1/2022. Bill number 22008481. Principal amount $20,222 even. Admin charge $4,246.62 for a total of $24,468.62.
Thank you. All
You're
right,
welcome.
Mr. Cohen?
Thank you. This actually is much like the previous case that my colleague Molly Costello just handled. This is a lien that is on the property at 1745 North 26th Street, but there is currently no personal liability for Rehab Sumrain. She was not issued a bill from this demolition. That is because at the time that the demolition, at the time that the imminently dangerous notice was sent and the demolition happened 5 months after that, the notice was actually sent to the previous owner, and then the bill that occurred after the demolition was completed was also sent to the previous owner. So at this point, there's no personal liability for Ms. Sumrain to contest within this board's jurisdiction. And as this board is already aware, municipal liens are under the jurisdiction of the Court of Common Pleas.
When you say notice was sent to the previous owner, was that the owner at the time of the demolition?
No, it was not. So the property was sold, but because of, I'm speculating, but I think because of an issue with the recording with the Office of Property Assessment, the notice was sent, the notice of violations, I should say, was sent to the previous owner at the time that the violations existed at the time
And
of
may
the
I?
date of that
May I?
notice.
Right, just a moment.
However,
You'll have a chance. You'll have a chance.
the property was posted on, I think, March of 2022 with an imminently dangerous poster, which itself is an appealable notice. That poster was not appealed to the Board of Building Standards. So 5 months later, the city moved forward with the demolition.
So the violation notice was sent to the wrong party. Was the bill
That's
sent
correct.
to the wrong party as well?
Yes, both were sent to the wrong party.
Was that ever corrected?
To my knowledge, no. So as far as I am aware, to date, there has been no bill issued to Ms. Sumrain, so she's not being held liable. And there is still I believe we're still within the 6-year statute of limitations under the MCTLA for personal liability. But that doesn't mean that there's anything here to decide, because it's not ripe yet. Until she is held personally liable, that would trigger her rights. So far, that hasn't happened and isn't likely to happen if the city can collect the amount of the demolition through the municipal lien.
From whom?
From a sale of the property, from going forward with the writ of Sere Facias action in the Court of Common Pleas.
Against whom?
Whoever the owner of the property happens to be when the collection action takes place. If Ms. Sumrain sells the property with the lien still on it, then she would not be that person beholden to pay the lien off later.
But if she still owns the property, you're now telling me that you would hold her personally responsible.
Under the provisions of the writ of Siri Facias and the MCTLA, but that's only if, again, she's got the hot potato at the time where the city initiates its collection action over the municipal lien.
Can you tell me the date or the lien number on this?
Ms. Mitchell, do you have the lien number?
No, I do not.
Would that be on the tax services site? Could we enter that into
Ms.
the
Mitchell,
record?
do you mind showing your camera? Witnesses should show.
Oh, I'm sorry.
It's okay, I just, for the people who are observing,
Okay.
just show the camera. Thank you.
You're welcome.
All right, so we don't have a lien number. We don't, do we know the date that this was leaked?
So, I apologize. Looking at the tax center website, and I'll ask Ms. Mitchell to confirm this. The lien number appears to be 579605. Is that correct?
Yes.
All right. Anything else, Mr. Cohen?
That's it for the city's opening remarks. Thank you very much, members of the board.
Ms. Sumrain, what would you like to tell us about this?
Yeah, so I had when I purchased the property, when I did the deed and the search on the property, there was no liens on it and no violations. There
When
was
did you
prior July of 2020. So the prior owner, there was violations that they took care of, just like sealing the windows and whatnot. Just violations on, vacant properties, basically. So when I purchased it, it was clear. And as soon as I purchased it, soon after I purchased it, I did receive violations from LNI here at my current address in Chicago, Illinois. And I have multiple violations from LNI with this address and my apartment number. And I immediately took care of the violations, which was to seal the doors and windows and to basically clean the property,
Mm-hmm.
And I did so. I did that and I complied immediately. And I also stayed in touch with the inspector who actually wrote the violations. And I had explained to him that I purchased this property for me and my children, and that we're in the process of starting the renovation when I could come up with the money to renovate the property. So I had told him, since I am not in the city of Philadelphia, I was going to hold on to his phone number and just continue to just monitor the property through property management that I had in Philadelphia, a company that would check on my property, because I'm not physically there. So I did receive violations here at my address. So LNI, they do have my address here. Now, what's really upsetting me is that this is the home that was supposed to be for me and my children. And I put everything that I had saved for this property. When they, and I also paid $15,000 for the interior demolition through a company to make the property safe so I don't, get any violations, to be in compliance basically with LNI. So then the violations that were sent after the demolition was done, they were never sent to me. I was never aware. So after the property was torn down, my property management guy was driving by and he just gave me a call and said, the property's not there. And that day will never be forgotten, because this was it needed a lot of work, but it was something that I never had before. It was a home. And I was never given a chance to basically contact LNI about the violation to take care of it, because the violation notice was sent to the prior owner. That's all I have.
Okay. Had you
Uh,
seen this property before you purchased it?
I did.
Okay, so you knew what condition it was in.
Yes, because my family, they live in, I was born and raised in that neighborhood. So I'm very familiar with the area.
The city could be able to do some cross-examination.
Yes, go right ahead.
Thank you. Good afternoon, Ms. Simrain.
Hi.
In March of 2022, did your property manager inform you that the property had been posted as imminently dangerous?
No.
Did your property manager inform you that they failed to get any permits for the actual renovation of the interior?
No, they did. Well, he's not the one that actually did the permit for the demolition. It was the construction company.
Did the construction company or did your property manager inform you that they had applied for an easy interior permit, but that they had not actually obtained the easy interior permit?
Well, they said they did obtain it.
Did
And
you
that's
check
how
on
they
the
were.
city's website or with the Department of L&I to confirm that the permit was actually issued?
No, I don't know about that. It's my first time owning a property.
Well,
So
what
that's
I mean
not
is,
something-
did you trust your property manager when they said, don't worry, we have it in hand, we're going to handle it?
Yeah, because he was opening the live camera and they showed me everything, the job that was done. And he sealed the doors and windows and everything was okay.
If the board would permit me to share my screen for a moment.
Yes, please.
So did your property manager show you this condition of the property as of March of 2022?
I purchased the property with this back exactly the way it is.
And if you'll excuse me, I'm scrolling down to
ahead.
Here.
That's exactly how I purchased the property. So the only thing that was done was to make it secure on the interior by cleaning it out and leaving the beams that would stabilize the walls.
When you purchased it, did you get an engineer's evaluation of its stability?
No, I
mean, it
did
is-
do
this
I did
photo-
do the deed to make sure that the property didn't have any liens on it. Like I said, there was
True.
violations that were taken care of. So the time that I purchased it, yes, I went through the deed company, made sure that the property was, safe and secure, and there was nothing against it.
So
And
the
that's
lack of
the back
support-
that you just showed us. That's exactly how it was when I purchased it.
But the lack of support beams here, which would be what would be the first floor of the interior and having nothing supporting it in the back to the basement, that is
Exactly
something
what
you
we-
can,
I'm sorry, I need to, I'm sorry. Exactly what are we looking at? Tell us what.
sorry.
I know what the first,
Over here is the rear of the property. And you can see there's some windows along the side here. This is a photograph taken through one of the windows. And all of this, I'll have Supervisor Thomas Robikowski of the L&I's Contractual Services Unit clarify and put this on the record. But as you can see from this shot, looking through the window upwards, there's no support members on the back second half, like the second floor of the building. And then this shot looking downwards through that window, there's no support members on the first floor. So essentially my question to Ms. Simrain is, without those support members on the first and second floor of the rear, did you consider that to be in stable condition?
Well, I had a company that specializes in this job, a construction company, a building company, who did made sure, and I paid for the job to be done, to be secure,
Was
to
this the
have it
same,
safe and secure.
was this the same company that took your money and didn't tell you that L&I had posted the property as imminently dangerous?
Well, there was nothing that said it was eminently dangerous when they did the interior demolition. I did
I'm
not
going
have
to-
the violations when
I'm
when
going
they
to
did the
scroll down
demolition
here
job.
to this photograph here. So what you're saying is your company did not inform you of this specific poster that's visible in the photograph on page 7 in the city's packet.
This is, you're talking about this after they did the demolition.
But the date on this poster is March 19th of 2022, correct?
Okay,
And when,
This
well,
is
let me ask,
after the
when,
this is after the demolition was done.
when do you think the demolition occurred?
I don't remember the exact date, but this is after the demolition was done. This poster was on there after.
Okay, but, well, actually, let me clarify. What demolition are you talking about? Because the building is clearly standing in this photograph.
Yes, the interior demolition.
Your
That I-
demolition that you did,
Yes,
you had
through a
done, okay,
company.
not the city's. Mr.
Right.
Talking about the city's demolition, is that correct?
Okay, so
Oh,
then,
all right.
so then am I correct in assuming that the company that you paid did an interior demolition without permits in your property, without your knowledge?
No, they did it with my knowledge. I paid them to do the interior demolition. So
Well,
I
what I
can
mean
have the
is-
property ready to start building the property.
What I mean is,
You know,
did they
you have-
misrepresent the permit status to you? You knew that they did the demolition, the interior demolition, but
Of
did you know
course.
they were doing it without permits?
No, they did not do it without permit because they submitted a permit.
Okay, I'll wait until
Well,
Supervisor
you can
Rybakowski testifies.
Yeah.
So when, well, actually, I'll leave it at that, I think. I'll stop sharing my screen. And just to clarify.
Yes.
Did you ever get your $15,000 back from this management company?
Why would I get it back? I paid them for the job.
But they did work without permits, and then the property was demolished by L&I. So have you asked them to give you part or all of that money back?
No, I did not.
Okay. Thank you
They
very
did
much,
the
Ms. Serrano.
job. They did the job that was, sought with my property management. So the construction company that did the demolition, the property management, he's into construction and he was physically there overseeing the job that was getting done. So they did the cleaning. They secured the property.
All right, so what, Mr. Cohen, why don't you move on?
Thank you. Well, if Ms. Simrain would like to offer a redirect or any other information or call any other witnesses, I'll hold off until she's finished.
Yeah, what's not right is that they sent this notice and the violation that it's imminently dangerous to the prior owner when they had sent me notices to my physical address. And they have my address. So the last violation from L&I was to seal the windows and the door was sent here to my physical address in Illinois.
When was
And then
that?
right
Yes,
after,
I think we understand that part, and actually, Mr. Cohen has admitted that there was that error.
so I wasn't even aware of,
Yep.
the property. And even though I have a property management company, guy, honestly, it's a vacant property and he's not, there checking on it every single day. There's no reason to, it's vacant.
Okay, I think we understand that posture. Mr. Cohen?
Thank you. The city would call Supervisor Thomas Rybakowski of L&I's Contractual Services Unit.
Mr. Rybakowski, good afternoon.
Good afternoon.
Could you state your full name and position with the city, please?
Thomas Rybakowski, RYBAKOWSKI, City of Philadelphia, License and Inspections.
Do you swear or affirm the testimony you're about to give in this matter will be the truth?
Yes.
Thank you. Mr. Cohen?
Thank you. Supervisor Rybakowski, could you very briefly tell the board how long you've been with L&I and in what capacity?
Currently, I am a construction compliance supervisor assigned to Contractual Services Unit or Emergency Response. Prior to me being appointed as a supervisor in June of 2021, I was a building inspector and plan review specialist assigned to the same unit, and that's since 2014.
Thank you. In the course of your duties as part of CSU, have you reviewed the records for and gone to the property at 1745 North 26th Street?
I have reviewed the case record, yes.
I'm going to share my screen again. And just to re-review what some of what was produced as an offer of proof, are the photographs in Exhibit C1, starting on page 2 in the packet, are those records of the L&I inspector taken of the building on March 19th of 2022?
Yes.
Can you say anything about the condition of the rear of this building as it appears in this photograph?
These photographs were this photograph was taken by Inspector Farley in response to an inspection of the property at 1745 North 26th Street. The property was declared eminently dangerous. There had been the roof essentially has been either removed or collapsed off the property. The main or the rear exterior wall and portions of that wall have been removed or collapsed off the property. And then the side wall along the vacant lot or the opening is essentially a freestanding wall in that a lot of the structural members have been removed from this wall.
Well, what's the risk of a freestanding wall?
Essentially, if the lateral support has been removed, the wall could potentially collapse from the property.
And scrolling down over here, is there anything else that you can add from this photograph?
From this photograph, it's another vantage point of the side load-bearing wall of the property where the structural members have been either removed or collapsed from the interior of the property, and the main roof has been removed or collapsed off the property.
And going to this photo on page 4, looking inside one of the windows, what can you tell us about the inside of this property?
It's another vantage point showing the amount of structural members that have been removed or collapsed from the property.
Now you heard Ms. Simrain testify that it is her understanding that some of this work was done by a company removing interior members. Was there ever a permit issued to remove interior structural members?
So according to the department's database, a permit was essentially created or entered into our system, and that permit was for a general easy removal, non-load bearing wall easy permit, and that was created in our system on March 3rd of 2021. With it being entered into our system, but then that permit was never issued by the department. There was a request for additional information from the plans review specialist or from permit services, which was never addressed by the permitting or by the applicant. And then that permit was eventually expired by the permit services unit, and that permit for any work being done on the property was not issued.
Well, to be clear in our terminology here, when you say the permit was expired, do you mean the permit application?
Let me rephrase. A permit was never issued for any work on this property, so there was no permit ever issued for any structural work for this property.
And if I could interject, and is it your testimony that is because the information needed to complete the application was not provided?
Well,
Is that why it expired?
So the permit that was entered into our system is an easy standard permit. So first of all, the permit that was entered into the system is for an interior demolition only, which means that you do not take any structural members. In looking at these photographs, somebody has come in and taken a lot of structural members and support from this property involving the exterior walls. A permit would be required for any structural repair, and it would be far more than just an easy alteration or an easy permit.
But is that why the permit, that's not why the permit wasn't issued?
No, this permit was not issued because the information that the department asked for was never provided, and it was essentially expired, but that's a notation in our system. It's basically abandoned or canceled.
Okay, that was my question. Thank you.
So based on Ms. Simrain's understanding of what happened, did the company or person who did this work do so without an actual issued permit?
Correct.
No. Okay, so can I?
Well,
Well, you have to wait, Mr.
yeah,
Cohen.
there will be an opportunity to cross-examine Mr. Supervisor Rybakowski. And just for the record, was that easy permit application GM-2021- 001895.
Yes.
Thank you. And just scrolling down to page 5, what, if anything, can you see in this photograph?
This is another photograph taken of the property through one of the windows, showing more structural members being removed from the property, or that they collapsed. But you can see that the joist pockets where the joists or the floor assemblies would be installed in this, which would be a load bearing or a structural member.
Well, do you see any debris in the basement of what would be a collapsed joist?
No.
Okay. Moving on to this photograph, page 6. What is this orange rectangle that's posted on the boarded window at the front of this property?
That would be the orange eminently dangerous sign that was affixed to the front of the property on March 16th of 2022 during Inspector Farley's inspection, declaring the property as eminently dangerous.
Just to clarify for the record, do you mean March 19th? The 6 and the 9 being transposed?
I said the date. Yes, March 19th of 2022.
Looking at the photo on page 7, does this poster itself explain that if corrective action isn't taken, that L&I will be authorized to do its own demolition?
Paragraph 3, or the last paragraph before at the document, if you fail to obey this order, the structure is subject to immediate demolition by the city at any time. The city will stucco the party wall exposed by the demolition in accordance with all applicable provisions of the Philadelphia Code. You will be billed for all costs incurred and administrative fees. Failure to pay these costs and fees will result in liens being placed against the title to the premise.
And I realize it's difficult to read because of the artifacts in the photograph, but at the bottom here, this bottom 2 lines, does this state the right to appeal from this posted notice?
From the posting that's affixed to the property, the last sentence on that posting does give the owner or the responsible party the ability to appeal the violation, and it is 5 days from the date of the posting. In this case, it would have been 5 days from the March 19th of 2022.
Was any appeal filed from this posting either within 5 days or later?
Not that I'm aware of.
And would you be made aware if there was an appeal filed?
Yes.
Scrolling down here to this next photograph, which the exhibit C2, these are photographs starting on page 8 and going through page 14. Supervisor, are these photographs that were taken by an L&I inspector in the course of their duties?
Yes.
And were these taken, I believe, August 30th of 2022, just before L&I initiated action to demolish this property?
These are photographs that would be taken by the demolition coordinating team at the time the property was placed to bid for demolition.
Is the imminently dangerous poster still posted on the front of this property?
No.
Scrolling down to page 9, is the rear of this property still in same or similar condition to what was visible from March of 2022?
It's still showing the removal of the roof assembly and the conditions of the exterior wall. It does show that overgrowth is starting to accumulate over the structure.
By overgrowth, you mean the ivy and
Vegetation.
vines? What's the risk of growth attaching itself to a freestanding wall?
Added weight.
Also, does it look like in the bottom corner here that some bricks have fallen off since the last photos were taken on March 19th of 2022?
The brickwork is all dislodged, so there could be some that have fallen or out of alignment.
Well, let's compare with what's on page 2 here. And then I'm going to scroll back down to page 9 here.
It does appear that some are missing from that section.
And is this another photograph inside the property as its conditions were on August 30th of 2022?
Yes.
All right, is this a notice that was sent out to the neighborhood about L&I's impending action?
Yes.
If you could briefly tell us what's the process by which L&I provides the notice, takes the bids, and schedules the demolition?
So essentially, on the day of the bid, which in this case was August 30th of 2022, the department will pass out letters to the adjoining properties, making those residents aware that a demolition will be occurring for a property. In this case, the property was 1745 North 26th Street. And it's also notifying those residents that if they notice anything unsafe, if they notice anything going on with the property, to contact the department, and the area inspector will come out to make sure everything's being done under the accordance of the demolition contract.
And then when L&I has the demolition contractors on site, how does it award a demolition permit to a particular contractor?
So in this case, the department will receive bids for the demolition. Those bids are submitted into the procurement office, and then the department will pick the lowest bidder and award that bid to that contractor. Once the bid is awarded, the contractor can start the demolition within 3 hours of winning that bid.
And scrolling down one page to page 15 in the packet, Exhibit C3, is this the demolition bid tabulation for 1745 North 26th Street?
Yes.
Who was awarded the demolition?
Palmer Construction was awarded the demolition. The winning bid was for $20,222. The bids ranged from that price through the 5 bids all the way up to $34,445.
And Pedro Palmer Construction was the lowest of these bids?
Correct.
And scrolling down to page 16, is this the demolition permit that was issued resulting from the awarding of that bid?
Yes.
And does it also show the same bid cost, same contractor that was awarded the bid for this demolition?
It does.
And just for the record, any of the highlighting in this and the previous document is added after the fact. It does not exist in the original. And what's the date of this demolition permit?
The permit was issued August 31st of 2022.
And just skipping ahead a bit to page 36 in the packet. What is this notice and how does it relate to the demolition?
This is the invoice for the demolition of the property. It reflects the price for the demolition, which was the $20,222, and it also states the administrative charge of $4,246.62.
And was this notice issued to Ms. Sumrain?
No, this notice was sent to the previous owner, ROI National Inc.
And just for the record, when this notice was issued, was ROI National still the owner of this particular property?
No.
So this was an error on L&I's part?
This was the department pulls the notices from the OPA. At that time, the OPA must not have updated the system, and the system pulled the old owner of the property. So the notices and the subsequent bill that went along with it went to that owner.
To date, is this the only bill that has been issued for this demolition at this property? Or for this demolition costs, I should say.
Yes.
Yeah, just to clarify, it's not, there was an additional site work bill. That's not what I'm talking about, correct?
Correct.
Okay. Thank you very much, Supervisor. I'm going to stop sharing my screen at this point. And if Ms. Sumrain has any other questions for the supervisor.
Yeah, I do.
And I'm happy to share anything on my screen if Ms. Sumrain wants me to put it back up.
So I do have screenshots of the OPA being under my name at the end of 2020. And he just mentioned that it was not updated. It was updated, and I took screenshots of it, and I have the pictures with me, the screenshots of on the city's website, the OPA. was under my name the end of 2020 because I purchased it in July. So it took a couple months until it transferred over on the website,
Can
the
you
city's
send them
website.
to me?
Absolutely. I can email it to you.
Sure. Can you write it down? Write my email down?
Yeah, I did. I just wrote it down.
Okay, can you send it over?
And I also have, that's how they, LNI sent me violations prior to this at my current address in Illinois.
Okay, did you have any questions for Mr. Ribikowski, though, about his specific testimony?
Yeah, I do.
why
So
don't
he
you-
said that, the roof could have, the roof removed or collapsed. Nothing was collapsed. And as you can see in the photos, there is nothing on the ground from anything being collapsed. It's all clear. As far as the back, the bricks, that's exactly how I purchased the property. And I also have pictures of how the property looked. The bricks were just like that, and there was no violations outstanding for the rear of the property. Now for the joists are exactly the way the property was when I purchased it. Also, I have pictures.
Okay, well, you would need to send them to Ms. Andre so that the board comments.
Absolutely.
And
Absolutely.
she would
And he
also
said,
need to share copies with the city so the city can review.
Yeah, that's what I just
Yeah.
said.
Thank
Yeah,
you. Oh, sorry.
and so, so he said also there was a 5-day to send an appeal. And like I said, they never sent me the notice, so I wasn't even aware for
How
me
often
to
did your
even
man-
appeal.
Do you know how often someone from your management company actually went to visit the property?
Well, it was like I said, because I was waiting to save up the money to start the renovation. He was just waiting on me to basically give him, the okay to start working on the property.
Okay,
So when we took care of, the notices from LNI for sealing the doors and the windows and making the property safe, there was nothing for him to basically be doing there.
okay, any other questions though for Mr. Ribikowski?
No.
No, okay. Mr. Cohen, anything additional?
Very briefly, I understand Ms. Sumrain's frustration, but I think it is clear to this board the frustration is between Ms. Sumrain and the company that cheated her out of her money. The
No,
company that-
the issue that I really have.
Mr. Ray, you have to let him finish. And
The
you'll have your
company-
opportunity.
This company took her money. They engaged in unpermitted renovations to structural members of this property. And the property was left in an imminently dangerous condition with bricks falling off the rear, with freestanding walls. They put it into a condition that required LNI to take immediate public safety action. Immediate in this case, meaning from March to August of 2022, LNI had posted this property, waited for an appeal. No appeal came, not within 5 days, not within 5 months. And then LNI acted in the interest of public safety to abate the imminently dangerous conditions by demolition. That's the city's function. That's our purpose, to protect public safety. And in this case, our error was that we sent the bill to the wrong party, which is an error that works in Ms. Sumrain's favor, because she does not have personal liability in this case. She didn't receive this bill. There is a municipal lien on the property because of the Municipal Claims and Tax Liens Act. But as we've discussed previously, as is in the city's position statement, that's a different process going through the Court of Common Pleas that has an entirely different jurisdictional requirement. So for what we are here to do today, Ms. Sumrain is the victim of this particular company and their practices. Unfortunately, the city needed to do this demolition for public safety, and the bill at issue was not even issued to her. So there's no jurisdiction here to assert over that bill. There's no jurisdiction over the municipal lien, so there's really no controversy before this board. As difficult as that is to understand, and as it doesn't jibe with Ms. Sumrain's frustrations. So I would ask this board respectfully to dismiss this petition due to those jurisdictional issues.
But essentially what you're saying is that you placed a lien on her property after sending a bill to an incorrect party, and that
That's
she's
correct.
now prejudiced by that, and the city has no
I would object to
process
that characterization
correct that.
because the city did post the property for 5 months, and the agents who she hired in the city hid this information from her. Someone removed that imminently dangerous poster. Chances are it was the people who took her money and did
Well-
not tell her about what they were doing to her property.
That's a supposition.
True, but I think it's one supported by the facts available.
Okay. Is that your closing?
Yes, thank you, members of the board.
Thank you. Ms. Sumrain, any closing comments, some that you just want to summarize quickly?
No, I'm really exhausted.
Okay, we understand what an ordeal all of this has probably been for you. Any board members have additional questions?
No.
Okay, so we're gonna move to our deliberations. Everybody stay where you are. The board is gonna step aside for a moment.
Hold on.
Just
George,
for Nancy.
waiting for
Yes,
Nancy.
Mhm.
All right. Think we have, all right, the tax review board is now back in session. Thank you everyone for your patience. Mr. Cohen, we have one question that we wanted to consider. We
Of
just,
course.
so the company that did receive the bill, ROI, whatever, is it the city's position that because they received the violation notices and the bills, that personal liability has attached to them?
Because I'm a lawyer, I need to say this in two ways.
Yes, please.
Technically, yes, because they did not appeal the bill to this board that I know of. So they, under the law, could still be held liable. But as a practical matter, I don't see the city trying a collection action against a party they now know did not own the property at the time the demolition occurred.
Okay, I guess my question, even should they come here, that do you believe, or would your position be that a successful affirmative defense would or could be that they didn't own the property at the time?
I don't want to weigh in on the other side if I'm going to end up being the attorney on the city side. I will say.
Well, they're
it
not
is-
here, but in theory.
Generally,
theory,
I'd say
if it
it is
wasn't
a pretty strong defense because under the MCTLA, the liability attaches on the date that the demolition or the abatement or improvement is completed. And I think the facts in this case speak for themselves. On the date that the demolition was completed, ROI National did not own this property. Beyond that, I think that's the statement.
That would not
satisfied
confer
with me.
first. Okay, and that would not, however, then confer in personam liability to this current owner?
The city would need
Patches on the
to,
date of the demolition?
well, the liability can attach on the date of demolition, but the mechanism by which the city actually enforces personal liability is through a notice, through a bill. So that bill needs to be issued to the owner at that time. Or sorry, the bill needs to be issued to the owner who was the owner at that time. And that's what causes the liability. And that's sort of the trigger.
And the city didn't issue that kind of notice.
Exactly. There has been no trigger because the city didn't send the notice out, which is our error. We admit that, but that just means that there's no liability here. Or sorry, there's no liability here for Rehab Sumray.
Okay, that's the city's position. We get it. All right, so the decision of the board right now is that we're gonna hold this under advisement because we want Ms. Sumray to have the opportunity to submit her photos and her documents into the record that she referenced. We do have the city's information and exhibits. Ms. Sumray, we would ask that you forward to Ms. Andre the photos you referenced, the violation notices or other documents you referenced, contracts that you may have with your management company or
The
contractor.
city does need to reserve the right to object, just in case there are objections to any of those documents the city has not yet received.
Yes, we will share.
I'm gonna submit the OPA that it was under my name prior to the violation that they sent.
Okay.
And I will also send the violations that they had sent me prior to all this, to this current address from LNI. I do have these violations with this address on it.
That would be perfectly acceptable, I believe. Share those with Andre. She will share those with the board and with Mr. Cohen. Mr. Cohen, you'll have the opportunity to respond after reviewing them.
Thank you.
And then the board will review that information along with the city's exhibits and documents, everybody's argument, and we will issue a decision at that point.
So what everybody should just look out for, there will be another letter from the tax review board that says that this case was held under advisement. And then when we are ready to schedule it, it will be just a reading of the decision, no further arguments. And then you'll be able to appeal from that decision or not.
Right. Do we need a vote on just holding it under advisement?
I don't think
John O'Connor, I concur.
so. We should anyway.
Nancy?
Nancy Cameron, I concur.
George Matthews, I concur.
All the ways I concur. All right, so Mr. Moran, this matter is going to be held in abeyance pending receipt of all of your documents.
Oh,
And
30 days for your documents, Ms. Moran.
yes, 30 days to submit them, which will then be shared with the law department, giving them an opportunity to respond should there be a need to. At which point the board will review all of that information in the record and issue a decision. So I believe that concludes our docket for today. Yes? Ms. Andre, yes?
Oh, yes. I'm sorry. I thought my.
Checking.
Yeah.
All right, thank you, everyone. We appreciate all of your time and effort, and we will convene again on Tuesday.
Thank you, everyone.
Thank you, everyone.
Take
Good
care.
afternoon.
Bye-bye.
Thank you.
Have a good evening, everyone.
Thank you.
Bye-bye.